And we're going to begin today's webinar. Thank you for joining. We have a great turnout today. My name is Jerry Blass, and I am the President and CEO of Compliance Assistant. And today's webinar is all about third-party security risk management. So in other words, for business associates. And we're going to start with first we'll go over the agenda. So the agenda is to cover the administrative information, the things you need to know administratively about today's webinar. We'll conduct some introductions. Why is this important? Why is third-party security risk management important? Then I'll introduce the panelists in more detail and go over the focus of each panelist. We have a great balance of legal, compliance, and IT from an information security standpoint. We will then get started with our three panelists, and most of the time for today is going to be focused on them from their perspective. Then we'll go into Q&A. I'm sure we're going to have plenty of questions that can be asked. And at the end, we'll go over some contact information for follow-up. So from an administrative information standpoint, this webinar is scheduled to run for 1 hour, and it is being recorded. All attendees are muted, but can ask questions in the GoToWebinar question panel. We will address questions in the last 10 minutes of the webinar. Links to the PDF version of this PowerPoint will be made available to everyone who registered or attended today, as well as the recording. So with introductions, today's webinar is being sponsored by three organizations, one of them being Compliance Assistant, and that's me being President and CEO. We also have Ken Ryer here, who is Vice President of Operations for Compliance Assistant. And then we have Cardin Compliance, Carla Kreitner, who's the Privacy and Security Consultant for Cardin, and Donna Grindle, President of Cardin. And then we have a company called Spear out of California, and that's Ray Ribble, President, and Rob Pruder, who's Executive Vice President. I should mention that Cardin is out of the Atlanta, Georgia region. We are very excited to have three excellent panelists. First one is Donna Michael-Ziris. She is Vice President and General Counsel for Atlantic Care Health System. We have Joe Piccolo, who's Vice President of Corporate Compliance in Spear Health Network. And we have Janice Jaffe, who is the Area Director of IT Operations and the CISO for Beata Health Home Health Care. So just to give you a little bit of background about myself, I have over 30 years of experience in healthcare IT, and prior to Compliance Assistant, I was the CISO before that term became so popular for a major healthcare system in New Jersey. In 2002, we founded Compliance Assistant with the goal to provide software and service solutions for HIPAA and IT strategic planning. And today we provide software and service solutions to over 100 healthcare organizations across the country for a number of regulations that are listed on this bio and more. So I was recently selected to the New Jersey HIMSS Board of Directors, and I head up the Security, Privacy, and Compliance Task Force. And we also have a LinkedIn group called HIPAA 411. Feel free to search for that on LinkedIn and join it. We would love to have you as members. So why is this so important? We know that with Omnibus, the HIPAA final rule, that BAs are equal to CEs in terms of HIPAA responsibility and liability. We also know that the information PHI that is in the hands of a BA is subject to potential vulnerabilities that must be assessed for risk and managed for risk. So the CEs must consider adding BA risk to their own risk assessment and risk management programs, since it is their PHI that is potentially vulnerable. CEs must show due diligence in regards to BA management and to protection of CE PHI. And BAs must also show due diligence in regards to downstream BA management and protection of CE PHI. In addition to the analysis for risk, there's also the agreements in which the legal part to make sure you cover, depending on the type of BA, being a high risk, medium, or low, cover the aspects legally that you want to make sure that they do in order to protect your PHI, and also to be in adherence with the Omnibus final rule as far as the agreements go. And the other aspect of it is to know and to protect your PHI if it goes offshore. And in some cases, BAs are not always upfront about that with their subcontractors. So you need to definitely make sure if any of your PHI is going to end up offshore. Some of our observations over the years is that many CEs do not have an organized list of BAs and or have not categorized them in risk tiers. And with all that is going on with cyber attacks, it is difficult for CEs to tackle this potentially high-volume effort with limited resources. Administering a BA risk management program is not a one-time effort and may require some tough decisions when there are known vulnerabilities. So now I'm going to introduce our panelists for today, which is the main part of our webinar. And we have first Donna Michael-Ziris. She is Vice President and General Counsel for Atlantic Care Health System. Donna Michael-Ziris is responsible for leadership of legal operations for Atlantic Care, overseeing a team of attorneys and other professionals focused on corporate law, regulatory affairs, contracts, employment issues, medical staff matters, compliance, internal audit, privacy and information security, risk management, and risk finance. Donna is a former and adjunct professor for Rutgers University School of Business. She earned her bachelor's degree as a Douglas Scholar from Rutgers University, and her law degree is from Rutgers University School of Law. Next, we have Joe Piccolo, and Joe is Vice President of Corporate Compliance for Inspira Health Network in New Jersey. Joe has over 30 years of experience in healthcare administration and is currently the Vice President of Corporate Compliance for the Inspira Health Network. Joe is a member of the Healthcare Compliance Association. He has lectured and published extensively on various topics, including compliance, patient privacy, and physician practice management. Joe is a native of Philadelphia and is active in various civic associations. He holds an undergraduate degree from the University of Pennsylvania and a master's degree in business administration from LaSalle University. And last but not least, Janice Chaffee is Area Director of IT Operations and the CISO for Beata Home Health Care. As an IT leader at Beata, Janice oversees a team of highly skilled IT specialists. Her duties include ensuring the successful implementation, evolution, and ongoing integrity of Beata's network and server infrastructure, risk management process, and IT security program. So Janice is also skilled in contract management and negotiations, compliance and auditing, and acquisition due diligence. Janice holds a Bachelor of Arts in Computer Science from Temple University and a Master's Program Certificate in Healthcare Informatics from Drexel University. So we're going to go right to the panelist focus and the panelists. So to give you a high-level review of what Donna, Joe, and Janice are going to focus on, Donna, from a legal standpoint, will discuss operational issues in identifying, risk scoring, collaborating with IS, auditing BAs, and discussion about recent cases and settlements. Joe will discuss partnering with IT and managing BAs from the compliance officer's perspective, and Janice will discuss managing BAs from the CISO perspective in a large national organization with many dispersed office locations and a highly mobile workforce. So let's get started, and we're going to turn it over to Donna to begin the panel discussions. Donna?
Thank you, Jerry. I'm going to start in opposite order of what's listed here, and I'm going to talk about some recent cases and settlements to frame some of the things that I'm going to talk about. So I'm sure, as all of you have seen from the recent publications, there's 3 recent cases from the Department of Health and Human Services that resulted in some significant fines in the last year and a half relating to business associates. First is with respect specifically to the business associate, finding liability for a business associate in Philadelphia, the Catholic Health Care Services of the Archdiocese of Philadelphia, who was serving as a business associate for a network of nursing homes. There was a fine of $650,000 imposed directly on that business associate related to theft of a mobile device of one of its employees, which was not encrypted. Additionally, there are 2 other recent cases imposing liability on the covered entity, not the business associate. In one of those, Raleigh Orthopedic Clinic, resulting in a fine of $750,000 for a failure of the covered entity to have a business associate in place with the vendor prior to providing patient PHI to the vendor. In addition, and more recently, another case was against the New England Health System. In that instance, the health system was fined $400,000. And this case is interesting because in this case, New England Health System had a business associates agreement in place with its vendor, with its business associate, but that contract was entered into in 2005, and they failed to update the business associate following high-tech, the adoption of high-tech. And so the OCR and HSS fined New England Health System, finding that every instance where New England Health System gave access to the vendor after September 23rd, 2014 until August 25, 2015, when they finally had an updated BAA in place, that every single one of those instances was a separate violation under the high-tech law, resulting in fines. And the overall fine to the health system was $400,000, certainly a testament to having to have your BA contracts, organized and up to date. So from a legal perspective, I wanted to talk to you about a few different elements. First and foremost, which I think are really highlighted by these cases, is the need to, at the outset, identify who your business associates are. You need to identify which of your vendors have access to PHI. In my health system, we centralize all contracts that come into our organization through the legal department. And as part of that process, we identify companies that may have access to PHI by using a routing form that actually has a couple of different prompts asking the requester to answer some questions which may flag that a vendor has access to PHI. And they submit that, that routing form along with the contract for legal review. In addition, in legal review, I've received a number of different contract requests where the requester didn't think that the vendor had access to PHI, but in the middle of our legal review, it's always something that we have on our radar. We've identified that, in fact, the vendor would have access to PHI. So it's very, very important to have an organization and a structure in place, whether it's centralized like we have here at AtlantiCare or something that's more decentralized, where you are identifying every vendor that may have access to PHI. Upon identifying a vendor who would have access to PHI, at that point, the legal department working with the Information Security Office actually would risk score the vendor, making it a high-risk vendor, a medium risk, or a low risk vendor, depending on the access that that vendor would have. Our high risk scores go to vendors who are remotely hosting our PHI, for example. Perhaps a medium score goes to a vendor who's regularly on site, who has regular access to our systems. And then the lower risk is one that may have access, but certainly lesser access or not regular access as part of their duties. So we risk score potential vendors, and then we collaborate with information security at the outset. Information security does an onboard analysis that's appropriate to the risk score of the vendor. And after they vet the vendor to make sure that there is information security controls at the company consistent with our requirements, they'll then set up a regular audit schedule for that vendor. Again, that's driven by the risk score. After information security vets the vendor and approves the vendor from an IT perspective, from an information security perspective, then the legal department will process the contract. And as part of processing the contract, we ensure that all of the business associates enter into a business associate agreement. First and foremost, we require any vendor that's doing business with AtlantiCare that will have access to PHI sign a business associate agreement using AtlantiCare's paper. We don't accept a vendor's business associate agreement, primarily because, as the covered entity, we have the obligation of monitoring and ensuring that business associates are meeting our standards. And so our business associate content is structured in a way that allows us to do expressly that. Specifically, our business associate agreement, in addition to requiring the business associate to comply with all of the applicable laws, does provide us with regular audit rights, where we can, confirm, in addition to that onboarding review, that the vendor continues to be in full compliance with the law and our policies. Our BAA is very specific as to breach instances, what constitutes a breach, the notice that we're required, the cooperation through the investigation, and then ultimately the notification to HHS and the patient, and who's responsible for what as part of that process, and also who bears the cost and the expense of that. And then finally, another major element of our BAA is, we prohibit offshoring of data, both offshoring of data for the vendor with whom we're contracting, and also with any subcontractor with whom the vendor, would enter into an agreement with. We only will allow a waiver of that offshoring prohibition if the vendor agrees to additional very specific information security guidelines, and then often too, it's with a pretty significant price concession for, offshoring the data. So, Jerry, that I think concludes the comments I was going to share. If we want to hear from Joe about some of the operational side of this.
Okay, Donna, thank you very much. And Joe, we hand it over to you.
Thank you very much, and good afternoon or good morning, depending on what part of the country that you're in. A lot of what Donna discussed really represents a best practice, and I think it's important to note it's a best practice, but it's also kind of the expectation of the government in terms of our responsibility as a covered entity in monitoring and working with our business associates. As a compliance officer, I approach it in the sense as I would with any type of compliance regulation that is under my purview. So it starts with education. One thing we've noted is, and Donna alluded to this quite succinctly, it's identification of who really is a business associate. It's taking that extra step and making sure that compliance has a seat at the table in developing the set of questions and the logic that you walk through to understand whether or not the other party really is a business associate. It's not always a clear-cut decision. And it's important to have a methodology, and there's a lot of resources out there from HHS and OCR that you can find that help you with making that determination. As you dig a little deeper working through from a compliance perspective, it's not just the normal contracted vendors who you would suspect. It's also making sure that you're aligning with your purchasing department, your materials management, all the other points of entry into your healthcare system, regardless of what type of system it is, to make sure that you're identifying and unearthing, if you will, the business associates who in fact are doing business with your organization. That's particularly true upon acquisitions. A lot of healthcare systems, and certainly Inspira is involved in this, as is most others, in the acquisition of physician practices. When you go into an acquisition, whether it be something like that, whether it be a new entity, where you're bringing in new vendors, and sometimes those vendors are not attuned to this issue as carefully as a hospital or healthcare system would. So it's important to start with that educational base, both within your workforce, the people out there negotiating the contracts, signing the vendor agreements, so that they're comfortable being able to at least call your number and inform you and get you involved early on in the process. I would also add with IT, it really is a partnership. One of the things that we've done here is set up a separate compliance committee focused on IT and security issues. And once again, as you look at the nature of the relationship, there are some nuances there. IT is kind of my go-to, as is our legal team would be, in terms of understanding the expertise I need to do my job as a compliance officer. I wouldn't pretend to be an attorney. I wouldn't also pretend to be an IT professional. And that's why it's so important to have those bridges built and that close working relationship. From compliance, what do we bring to the table? We bring the investigative techniques if, in fact, there is a breach. We bring the risk assessment through our annual work plans, and it's important, certainly, to have these type of projects related to risk assessments of our vendors, and looking at our business associate agreements, looking at our underlying contracts and how they're managed as part of an annual compliance work plan. And what that does is really several things. It brings it to the attention of your senior leadership and ultimately to the board or governing body of your organization so that they understand, as well as you do, the significance of these issues. Donna outlined some of the fines and penalties that have come out of these, issues that are uncovered. And it's important that your board understand that. So once again, it's important that compliance facilitates that discussion, but also lends its area of expertise in helping IT, for example, to seek resources that it would need to do its job. This is kind of a burgeoning situation for all of us. As compliance officers, we sit and we look at our FTEs and make sure that it's appropriate for the organization. But it's much more expanded than that. It's also partnering with IT, who now has the burden of trying to comply with these rules and regulations and help us in partnership to monitor what our business partners are doing and to set a regular schedule of risk assessments, as Donna said, based on the risk to the organization. So it's important that we also be their spokesman and help them to get to the table to compete for resources and also to stress the importance and significance of these very, very important topics. And with that, I will conclude my initial remarks and turn it back to you, Jerry.
Okay, thanks, Joe. And next is Janice from Beata Home Health. Janice?
Hi. I would like to add to this that, interestingly, my role has been mostly in infrastructure, and our company has started out mostly with paper. I'm probably very much like most healthcare companies. We started out paper-based, and it was really a very low-risk process in terms of our PHI. We locked our cabinets, and we could follow the paper. And now as we move, we're transitioning, and the entire landscape for Beata has changed over the last, I've been here 15 years, so it's slowly changed, but it's really taken a dramatic change. We're replacing a legacy system, and we're now embarking on a lot of pilots, and the work we're doing with business associates is dramatic. And it's interesting also to note is that we're both a covered entity as a healthcare provider, and we provide group health insurance to our employees. So we have a couple of different angles that we have to take a look at, and we're also in it have associations with various entities where we're the business associate providing managed services for various hospitals. And so all of that I am seeing, unfolding before me, the work of the business associate, the third-party entities from all different angles. And that has created an enormous risk management process for us. So what we have found is that, as a person who gets audited, that it is extremely time-consuming. And if you look at the different frameworks that are out there going on, various third-party assessment, services out there will develop their own framework, A lot of them are mostly after the National Institute of Standards, but they can be very verbose and take hours to respond. There is we're a CHAP accredited organization, so if you're familiar with CHAP, it's like JCO for it's Community Health Accredited Program, and they're now developing their own framework for IT security. Of course, we know that the OCR has phase 1 and phase 2 auditing, and now, they have their set of auditing procedures and a framework for that, to hit the regulations. And now we have high trust that's out there. So all of those different frameworks, I've been working feverishly to try to crosswalk all of that information. So there's from the perspective of somebody on the end of working through this, it's time consuming to answer, verify, obtain or provide supporting documentation, and that is all expensive and challenging. And when you have to go to the organization to fund all this, what you do have to do is kind of work to explain to them, how much it would cost for the remediation, how much it would cost to investigate breaches, how much it would cost for sending out breach notification letters, Donna's point, there's a lot of fines going on, class action suits. So, we've had to really work hard to get funding in order to manage all of this. And I'd like to say, talk a little bit about our process, because, my colleague's point, we really have created a very teamwork atmosphere in order to address business associate agreements and making sure our risk is addressed. So our legal department really is responsible for our contracts and making sure that business associate agreements are completed. In IT works in concert with them to do that risk assessment, because initially they were doing the risk assessments, and we began to see that there were things that were hidden. They didn't realize things were going offshore and things of that nature. And we all know that offshoring is a very up in the air item in terms of where the OCR is going to land on the ruling on allowing us to even have anything offshore. But and then we use our compliance team to have oversight for all this. So in general, we have to be working, all three of us, in concert to make sure that we're covering all the bases. I would say that we turn to a software tool to help us. We're trying to get everything standardized. I implemented an online system. Not trying to advertise here, but I am using Compliances, and I found it actually through Inspira as being audited by them. But it made things a little simpler. We're now using it. I have a tool that now I can automate it. I can do some things. So we're looking to reduce that cost because it is so costly to manage. And we have hundreds of business associate agreements, and so it becomes an interesting piece of our work and again, we needed to really paint the picture about how much it required funding. So we've been lucky so far, and we've been able to tackle all the different security issues that have come up. But everybody wants to ask the same question in many different ways. With that, I'll turn it back to Jerry in case anyone has questions.
Okay, thank you very much, Janice. And we're going to head into now the Q&A part of our webinar today. We have some excellent questions that have come in. So we're going to begin. The first one is for Donna, and all three panelists, feel free to join in and interact on any of these questions as we go. So Donna, the first question is regarding the business associate that was fined $650K. Was the fine due to non-encrypting, or was it due to having a contract to encrypt and they didn't encrypt as promised?
So the fine for $650,000 was with the Catholic Health Care Services, the Archdiocese of Philadelphia. It was a theft of a mobile device from an employee's vehicle, and the data on the device was not encrypted. That was the basis for the business associate did not meet the safe harbor, and accordingly they were fined. A situation like this in a covered entity situation would really result in a much higher fine, in my opinion, and you can see that from some prior cases from HHS. I really think, given that it's one of the first situations where a business associate was directly fined, and again, given the nature of the services that this organization was providing, that the fine is lighter than we've seen.
Okay, thanks, Donna. So the next question I'll provide to Joe. So Joe, the question is, what is the risk for the CE and the BA if there is no BAA in place?
What is the risk?
Yeah, what is the risk? Sounds like there's some risk there.
Well, I mean, the risk starts with the legal risk. I mean, some of the cases that Donna outlined, you cannot share protected health information with a business associate unless you have the agreement in place. There are specific fines and penalties from administered through the Office of Civil Rights that would govern this. They're on their website. They are significant, and it really depends on the level of risk. But under no circumstance should you share protected health information unless there is a business associate agreement fully executed and in place before any information is shared.
Okay, thanks, Joe. Donna, did you want to add on to that, or is that pretty much straightforward?
No, I think it's pretty much straightforward. Great job, Joe.
Okay, thanks.
Joe, Jerry, I'd like to add something. This is Janice. One of
Sure.
the things that I learned over the years, I worked for a pharmaceutical company, and there used to be a philosophy, and even when I started with Beata, there was a philosophy never to have a policy that you weren't able to fully comply with. Well, I think this has finally turned the concept of not having a policy unless you can fully comply is really turned on its head, in that you really have to have a policy, even if initially you're not able to comply with it, because if you don't have a policy, and I've seen a few of these fines, they consider it to be willful neglect, and that's where you get the biggest fine. So you can have a willful neglect corrected, or you can have a willful neglect uncorrected. Not having that policy becomes your biggest risk for having the largest fine.
Okay, thank you, Janice. This next question sounds like maybe a personal experience here. What happens if a CE tells the BA they don't need encryption on mobile devices? It sounds like a loaded gun. Who wants to take that one?
Well, I think we've mentioned it already a couple of times, but I think you really point to the New England Health System, the Catholic Health System case. Clearly under high tech, for the first time, business associates have direct accountability and direct obligations to comply with these privacy laws. That's not waivable by a covered entity. It's not waivable by any party. So you need to make sure that you're in compliance. Certainly encrypting the data will afford you a safe harbor for a breach, but there is just example after example after example in the last several years where covered entities, and now in this more recent case, a business associate, failed to encrypt data on an electronic device that went missing or was stolen, and the fines associated with that are just astronomical. So, I really would urge a business associate, and certainly my clients, I would tell them that we would not, if we're going to be providing or we're using electronic devices in the scope of our services for for a covered entity, you really need to encrypt. I mean, I think that, the government has been clear with these cases and with these fines that to do otherwise is really foolish.
This is Joe, and I've seen cases where, and this comes up, I think, with medical staffs or physicians, where they're used to using, smartphones, iPads, et cetera, and want the ability to text information. My advice, very similar to what Donna said, is, there's 2 points that you really have to set here. One is where you set your firewall in your organization. Anything in terms of emailing information that's within the firewall, and this gets confirmed through your IT department, is encrypted and is secure. But once you get outside, that venue, and what I've found and what we've seen in the industry, a lot of times physicians, like many of us, may have accounts which are Yahoo accounts or Google accounts, Gmail accounts, that sort of thing. And our IT professionals have always lectured to me about how unsecure those things are. So it's really working with whoever is requesting this to really hone down and say, if you're in an unencrypted environment, this is what you can't do. And when you order it down to that level, there's very little they can do. The other thing that we look for is, especially now with the technology and text messaging and emails and things like that, there are alternatives that, you can have encrypted devices that are perfectly safe to do that. And that's kind of the direction I think, that a covered entity really needs to head in, rather than trying to make an exception here around the rule that you require encryption.
Okay, thanks, Joe. Janice, any comments on that?
Yeah, I would. I'd also like to mention that my experience has been there was an attempt to circumvent the need for encryption by de-identifying PHI. And to be honest, that is, we really had to, get our handle on that, because I think, it's not possible really to trust that that our employees will know how or will, de-identify things properly. And that, that really won't work for you to, as an insurance policy, to be sure that, you're not sending, PHI. So, really, having implemented, data loss prevention, or, that, where you have, various leakages that by using external emails, going to external websites or things of that nature, using text messaging, all of those are, mechanisms for data loss. And, you have to put, some policies or technology in place in order to prevent that.
Okay, thanks, Janice. The next one is an interesting one as well. We know that BAs that have a lot of clients would certainly love all their clients to adopt their BAA. And on the other hand, CEs that have many BAs would love for all the BAs to adopt their BAA as well. So maybe I'll start with Donna here. So Donna, in your experience, how has Atlanticare succeeded in utilizing the Atlanticare BAA for most of your BAs, or has there been a mix?
Well, as the covered entity, you have the responsibility for your patient's data, and you have the primary responsibility for the business associate and how the relationship unfolds. So we've always taken the position that the business associate has to be on Atlanticare's paper. I don't want to say we've never made an exception, but in my 10 years with the organization, I can say we've made the exception less than 5 times. And they were really for large, national, prominent organizations whose product we absolutely needed, and they were just unwilling to negotiate it anyway. If we wanted the product, we had to use their business associate. And so in those instances, we negotiated the terms that we needed to have in their agreement. But by far, that is the exception and not the rule. We've just, stick to maintain that as the covered entity, we have the primary responsibility. As the covered entity, you can't be in each instance looking to a specific business associate to try to business associate agreement to identify what your obligation, what the BA's obligation is in this agreement versus that agreement versus that agreement. You really need to have some standardization that your information security folks can be comfortable with, and that really sets the expectations for all the vendors with whom you're doing business.
Joe, how about you? Have you had the same experience with the breakout?
Yeah, very, very similar. I mean, we start by stressing that it's our protected health information, and it's our obligation to really set the standards. As Donna said, I mean, there have been some large national vendors where there is a little bit of negotiation, but that's rare. Most vendors understand the rationale behind it and will sign. Where we've run into issues sometimes, are those companies that don't normally do business with healthcare and come in and may have a service or provide a service which crosses over where there is the sharing of protected health information. And there it becomes more of an education about the process. There's always a sense, perhaps, that these things are negotiable, as the underlying contract itself is. But when you work with the team at the other organization and help them to understand the rationale, it becomes less of an issue. And as Donna said, most vendors are willing to sign what we have in place.
Okay, thanks, Joe. And Janice, your organization.
Actually, Jerry, let me just say one more thing, if you don't mind. I think the other thing that's really helpful in that regard is the New Jersey Hospital Association. Following the passage of high-tech and the implementation of the omnibus rule, they put together another great resource of materials around compliance with the law. So at least for those of us who are in New Jersey, we contributed to and use, all of us pretty much, the same business associate form that's part of the NJHA's publication. And I think to the extent that you have standardization like that in a state, it's much easier to maintain consistency with the vendor that this is the form that we're using, because frankly it's the same or very similar form that the rest of the entities, I know at least in our state in New Jersey, that we're using.
Okay, Donna. That's great information.
Jerry,
Janice,
I was just going to add one comment to that as well, is that there's actually been a benefit to Joe's point about some of the vendors out there don't know what it really means to be a business associate and the responsibilities that they have, and some of them need some education and training, but some of them are very willing to go through that education and training because they want to get into the healthcare industry, and so they will do things, they will provide very beneficial agreements, for the entity that's willing to bring them along and educate them in that process. So it's been somewhat of a windfall in a few circumstances for us.
Great. So Janice, being an organization that is both behaves as a BA with certain contracts and a CE with BAs, how does all that get managed with such a high volume of locations and contracts, et cetera? It must be an amazing challenge.
It definitely is very challenging, very, very expensive amount of work, but as I mentioned, we're working on trying to standardize the way that we're doing things, automating the annual renew process, delegating some of the analysis work, and then working very tightly with our legal office and training them on, I think, Donna, you called it a routing type document. We're working on that with our legal department, making sure that they have the right questions and, the triggers when they need to be, when they need to make sure that, oh, this is an IT contract, I need to get this over to IT. So, those are all pieces of the puzzle that we're putting into play. And I would venture to say a lot of organizations are going through the same experience.
Okay, great. Next question for Janice. Maybe they didn't hear your comment, Janice. Someone wants to know what tool you use that you mentioned.
I was using ComplyAssist, And I should tell you that we are also looking to become high trust certified, and possibly SOC certified, and that we are using Compliance because it is a much user-friendly product for the people that you actually have to send assessments to. The other ones are a lot more verbose, and the other audits that I received are paper-based or Excel spreadsheets that you have to fill out. You have to send them, zips of documents and things of that nature. So, so it's been, been a great product to work with. So, not to advertise here, but that's how we're, working through our automation processes.
And the same person is asked, is there a sample of questionnaires that they can see? So can we send it to them? That's something that we can take care of for that person who asked that question. One interesting thing is we all know that medical devices have been identified as a high security risk. They haven't, totally stepped up to the plate in protecting PHI. So maybe I'll start here with Donna. When you get a contract, when you're contracting for a medical device company, what other considerations come into mind, knowing the history of security vulnerabilities there?
I strongly rely on input from my information security officer for, in this arena. We just, I'm sure like a lot of health systems around the country, replaced our pumps this year. And, in that contract, that very large contract negotiation, as well as many others where we have, medical equipment, that is interfacing or connecting wirelessly to other equipment, I really rely on my information security officer so I can get an understanding from them about exactly how the equipment functions and then get their input on what kind of restrictions or what kind of protections or what kind of, programmatic elements that they recommend that this equipment have to operate as safely as possible in our environment. And, our information security officer is, highly responsive. We work with him, all the time. We have a very good partnership. And, they've always been available to provide me with that, with that information. And then, of course, I embed that in the contract, and that becomes really a non-negotiable point, for that element of the equipment.
Jerry, this is Joe. I mean, there's something that I've seen and we have been very sensitive to is when there are implantable devices that have distinct serial numbers that align themselves with patients. For one example that I can recall is, and it's perfectly legitimate in terms of patient safety, but it also has to be covered under some sort of business associate agreement, is where embedded in a purchase order, you're ordering a very unique device with a vendor where the patient's name is on there. It links to a device number or identifier. So it's important to make sure that you're considering that as well. The other thing from a practical perspective that I've seen is some of our equipment, now when I say our industry's equipment, where there may be embedded PHI that's kept in there. You think of something as innocuous as a multifunctional copier where you could fax and it stores information that, eventually becomes antiquated, winds up in some trash heap somewhere. That may be loaded with protected health information unless it's properly removed from that device before it leaves your organization. So this is more the operational side, certainly, of HIPAA compliance, but these are some of the things that, over a long career, as witnessed by my picture, I've kind of seen come to fruition.
Okay, great. Thanks, Joe. So we still have a few more questions here, which is great because it's going to lead us up to the 1 hour time frame. So what have you all experienced for how long from the day you began to try to organize your inventory, to risk rate your BAs? And I know that that also depends obviously on your volume of BAs, how many BAs you have. But what's been your experience and how long it actually took to get properly organized? Maybe we'll start with Donna on this one.
To get the whole program organized, Jerry, or are you talking about on an individual case?
Well, on your inventory, understanding the scope of your inventory, how many BAs you have, go through them and rate them on risk, and then put a program in place, for periodic assessment.
Well, we turned on that program here, with the advent of high tech, and then with the omnibus rule, did some additional changes. We really, when we with the advent of high tech and every single contract that came through that required a business associate, we risk scored, enrolled them into the program at that point. And then for the existing business associates, we needed to update their business associate agreements in any event to comply with the changes in the law. And so at that point, we went ahead and we risk scored them at that point as well. And then they were already, they were already undergoing some audits. We just, classified them in the risk score. So, in terms of putting the entire program into place, it really was, it was a Herculean effort with respect to our existing business associates at the time to make sure we had those properly identified, to get the new agreements out to them, to make sure we got signed agreements back so we were completely ticked and tied. To the extent you can, ever be completely ticked and tied in this arena. I'd say that whole process took us a good 6 months, I would say. And we still do struggle with, how we have organized, the business associates. I mean, we have redundant information. So we have actually 3 different repositories where we have business associate agreements, which is not the most efficient. And we're actually in the middle of a project right now at Atlantic Care to really identify one source of truth for our business associate agreements repository and for pulling that information on a risk score basis. So that we're in the middle of that project, and I would imagine that project's going to take probably about 8 months to complete.
Yeah, nothing's easy with this. Joe, how about yourself?
Yeah, I mean, it's a difficult question to answer because, as you said, Jerry, it kind of goes to scope. It's certainly 6 to 8 months, as Donna said, is reasonable. It takes longer. It's a work in progress. I think, it's really looking and approaching as you would any other project. What's your scope of service? What's your time required to fully vet each agreement and to put it into a systematic way? And what are the resources that are allocated from your organization to do so? If this is a manual process, it's going to take you forever and a day. If you have tools available to you, either through consultants or tools that are, online based or, things that you can utilize, it makes a lot more sense and kind of helps streamline the process. So I would push back. If I were sitting in front of my CEO and said, how long is this going to take? I would say, what are the resources that I have at my disposal? Because that helps me to, develop a time frame that's realistic. We do know that the clock is ticking. We do know that the government has been very aggressive in pursuing cases along these lines. So that helps also the argument in terms of looking at the risk related to noncompliance with this.
Okay, John, it's kind of even venture there with you and your organization?
About the same time period that they mentioned, and Joe, I think, hit on a point about the OCR and the phase 2 questionnaires that are going out. And the number one thing that they are looking for is your list of business associates and whether or not you've assessed each of them as to what kind of risk they are. And that's like the number one thing. If you can do anything, it's get that list together. I think you have 10 days to answer the questionnaire, but get your BAAs, get a comprehensive list of your BAAs, and make sure that you've applied that risk. And everything else will kind of fall into place in my mind after that. But that if you don't already have that list, that's where the time's going to come into play.
Okay, thanks, Janice. I'll start with Donna again here. So Donna Atlanticare had an experience with a vendor who refused to, let's say, answer security questions after contract and maybe even provide proof of what they're doing to protect your data. And then if that's the case, if it did happen, what's been the experience with the options you can take to, what you can do about it if they don't want to provide that information?
We've never had that situation for existing vendors where we had BAs in place. We have had that vendor with that situation with new vendors who have either blown off our questionnaire that our Information Security Office issues, and our experience has been vendors who are not in the healthcare arena or solely in the healthcare arena, actually, in this area. So there's two that I can specifically recall where they just refused to cooperate with information security. In both instances, we didn't proceed to contract. In the one instance, the vendor ultimately came around reluctantly and gave us all the information we requested, and you can be rest assured that our information security officer went double down on that information before she would give that vendor the all clear. In the other instance, the vendor just refused to cooperate and was only half-heartedly cooperating, and we just refused to contract with them and went with another vendor in the space.
Well, that's interesting because usually the best time to get answers is pre-contract, so that's very interesting that it worked out like that. Yeah. Joe, how about you?
Yeah,
have you had experience?
No, it really hasn't come up because, as Donna said, you almost put the line in the sand that if you want to do business with our organization, these are kind of the guidelines and the rules. And predominantly that addresses any concerns that a vendor might have coming in to the organization. So I would say it really hasn't been an issue here.
Okay, great. Janice? Same question?
Yeah, same answers. So basically, we don't, we do an assessment as part of the contract, and if we see any gaps, we make the agreement contingent upon them, addressing the gaps, and or we just can't do business with them. We have to protect the data.
Okay, I'm going to throw this one up. We have about 3 minutes to go here, and so I guess the question I have here is if you have all these legal terms in your BAA and requiring the BA to do things to comply, do you actually have an audit program when necessary to make sure that they are? Have you implemented, for example, if a BA is supposed to notify your organization when an employee of the BA is terminated, and that BA employee has access to one or more of your systems, do you do an audit to make sure that they are actually notifying you in a timely manner? Something like that. Anyone can take that.
I have to defer to the information security folks because I know that our group conducts regular audits, but I honestly don't know the elements of the audits.
Okay. Anybody else?
Yes, the same here. It's part of our work plan, and there's a methodology involved that goes through our IT department. I rely on them. Great.
Janice?
Yeah, it's the same thing. We have identity access management tools. We audit our logs frequently to make sure that things were changed timely. And we hold each director accountable to ensure that notification of any terminations, whether it's via a vendor or an agreement is associated with the director, and if there's any disparity in that. We hold them accountable.
Okay. So I guess the final question is, maybe it's an easy one, maybe it's not an easy one, but the question is, Donna, and maybe even Joe and Janice, would you be willing to share your BAA with the folks? Well, with one particular person who asked that question, who's attending today.
I'd be more than happy to do that.
It's great.
Same here, Jerry.
Okay, Joe. We'll make sure that that person who asked that question is, we'll let you know who that is. Or if you want to send me your BAA, I can send it to them. So that brings us to the end of the Q&A. And I want to thank Donna, Joe, and Janice for doing a great job with their presentations, their discussions, and with their answers to the questions. I think all of our attendees can see that we had a very talented panel today, and we also had a diverse panel from a legal, compliance, and IT and CISO standpoint. Great balance there. So just for the remaining minute, we're just going to show that in this PowerPoint that we're going to be providing a PDF format version to everyone. We do have contact information for Compliance Assistant and for Carden and for Sphere. So once again, thanks for attending. This webinar is now over. Thanks to you, Donna and Joe and Janice. And, many thanks. And we look forward to another webinar at some point in the future. Thanks to everyone who attended today, and we'll get everything out to you by tomorrow. Have a great day. Bye-bye.
Thanks. Bye.
Thank you. Bye.